On this episode of Law Weekly, we bring you the concluding part to our series on electoral jurisprudence and the legal system. This time we'll be speaking to yet another senior advocate of Nigeria, Mazi Afamosigwe, his view on how the judiciary has fared and the quality of justice delivery. Also on the program, an induction ceremony took place in Lagos for the newly conferred senior advocates of Nigeria, and the focal point of the conversation, upholding the tenets of the profession following their elevation. Plus, we head to the Supreme Court of Nigeria for the special session of the 2023-2024 legal year, where the Chief Justice of Nigeria, Justice Olukayode Ariwola, gives a breakdown of the number of cases that came into the Apex Court in the past year and other issues affecting the judiciary in recent times. Plus, a recap of the trending stories from the courts. Hello and welcome to the program. I'm Millicent Walker. The law remains the law, no matter whose interest is involved. In all we do as interpreters of the law, we should endeavor to sever the strings of emotion from logic and assumption from fact. Words from the Chief Justice of Nigeria, Justice Olukayode Ariwola, who x-rayed some of the burning issues affecting the judiciary, besides conferring the prestigious rank of Senior Advocate of Nigeria to 58 legal practitioners.
The ceremonial courtroom of the Supreme Court comes alive for the conferment of Senior Advocates of Nigeria on 58 lawmakers. They are joined by family and friends. In attendance are former Chief Justices of Nigeria, retired Justices of the Court, and other top government officials. The Justices, led by the Chief Justice of Nigeria, arrive. The new silks thereafter take their oath of allegiance.
Faithfully serve the interests of the Federal Republic of Nigeria. Faithfully serve the interests of the Federal Republic of Nigeria. In the capacity of Senior Advocate of Nigeria. In the capacity of Senior Advocate of Nigeria. Thank you.
Congratulations.
The CJN uses the occasion to address recent happenings in the judiciary.
I must say, with great pride and excitement, that during the outgone legal year, we'll experience so many positive, heartwarming developments in the Nigerian judiciary. In response to the yearning need for the injection of fresh blood into the nation's judicial service, we were able to appoint and subsequently swear in 23 new judges of the Federal High Court on Wednesday, the 4th day of October 2023. In the same vein, on Wednesday, the 20th day of September 2023, 9 justices of the Court of Appeal were inaugurated to strengthen the seamless dispensation of justice at the appellate level of adjudication in the country. What has been pending for a very long time, even long before I assumed office in June 2023, is the appointment of justices to fill the many vacancies that have been created as a result of deaths and retirements of our brother justices. For the first time in the history of the Supreme Court, 8 honorable justices were sworn in to fill the positions vacated by our esteemed colleagues who retired, as well as enlarging the profile of our judicial strength by increasing the number of justices to an all-time high number of 20 in November 2020. That, indeed, was first of its kind in our history.
The Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, wants the National Judicial Council to intensify efforts on appointing more justices to the Supreme Court.
We must begin to develop innovative solutions towards enhancing the working capacity of the Supreme Court, cutting down on the number of appeals that gets to this honorable court, implementing critical judicial reforms, as well as adopting alternative dispute resolution mechanisms. I am aware that the process of filling the vacancies for the justices of Supreme Court has begun. I would, however, like to use this opportunity to urge the leadership of the National Judicial Council to fast-track the process of achieving a full complement of the Supreme Court and to also concurrently put in place the process of filling the consequential vacancies that will be occasioned at the Court of Appeal to avoid undue delay and minimize disruptions at that level.
The president of the Nigeria Bar Association speaks on the challenges facing the judiciary in recent times.
My lords, there has never been a time in our history that judiciary came under attack like this time. And my lords would agree with me that more than 90% of these attacks stem from election-related matters, which in so many ways have affected the other matters being handled by the courts. The question is, why do we have the preponderance of these accusations arise from electoral matters? In cases dealing with politicians and political interests, the way politics in this country is played frightens me every dawning day. It is a fight to finish affair. Nobody accepts defeat at the polls. The judges must be the final bus stop. And when they come to the judges and the judges in their professional minds give judgment, they call them all sorts of names. To the party who wins the case, the judiciary is the best place, a real common hope of the common man. To the party who loses, the judiciary is bad. Even when a party loses a case because of a serious blunder of counsel, it is the judge who is blamed. Why? My lord, I repeat, even when a party loses a case because of a serious blunder of counsel, it is the judge who is blamed. And my Lord Honorable Justice Nipitobi asked, why?
If the assurances of the Chief Justice of Nigeria is anything to go by, many Nigerians will expect a quick dispensation of justice and full confidence in the judiciary.
Welcome back. And just before the conferment of Senior Advocate of Nigeria to the lawyers, there was an induction ceremony held on what to expect following their elevation, and not just that, but also maintaining the integrity of the profession. Take a look.
The body of Senior Advocates of Nigeria, BOSAN, held the induction program for the Silk designates in Lagos. It had the theme, Legal Ethics and Professionalism in the Practice of Law. A rich faculty of seasoned legal minds from the bar to the bench took the new silks on issues ranging from dress code and decorum to professionalism, excellence, ethics, and discipline.
The rank is a privilege. It is not a right. I like to emphasize that. It is a privilege, and that's why you applied to. You were filtered by. You were interviewed by. And then conferred this great honor by the Legal Practitioners Privileges Committee. It's a privilege. And what that means is that that privilege can be withdrawn. As a matter of fact, this body, the body of Senior Advocates of Nigeria, did recommend procedural rules for the withdrawal of the rank of Senior Advocate of Nigeria. And that includes suspension, admonition, and withdrawal. Absolutely.
I have been in court on several occasions, in particular the Supreme Court, where Honorable Justice Mary Odilia then said to a senior advocate who was brazenly arguing what he knew was false, that she was going to report him to the LPPC if he continued that line of argument. And when she said that, he stopped it. So it behoves you to always be forthright. You don't lose anything by being forthright.
The balance of the society will be irreparably damaged if lawyers cannot be trusted by their clients and society. Lawyers must take heed and not play the team god in a society which is dependent on their knowledge, honesty, and fiduciary dependability. If lawyers cannot be trusted, who then should the people trust? the legal profession should rid itself of dishonest characters in their midst.
Against the backdrop of conversations on the integrity of the process of selection for elevation to the rank, facilitators at the induction also stressed the need for the new silks to maintain the integrity of the profession.
Now, mind you, we're in a very complicated society, so where everything is failing. Therefore, if everything is failing within a society, it's the process by which you were elevated, not also failing. I want you to answer that question yourself. The some of you are sitting here who will be distinguished, no doubt about it, but by some who may have stretched the process, undermined the process, and perhaps abused the process. That is the test as to whether or not you are deserving. And that is the test as to whether or not the reputation still remains real or it's just a myth.
No process is perfect, but I think the Privileges Committee have always been trying their best to pick the best of the applicants. I do recall that I was once chairman of the Appeals Committee. Therefore, those of them that were not picked and had genuine reasons not to be picked, they had this right of coming to the Appeal Committee. And in many cases, such people that have good grounds that they should have picked them will recommend them and they still pick them. So I think they are good candidates.
We realize that we are at some crossroad in this country. It is common knowledge that the public has expressed opinions about our profession, the quality of what they believe they are getting from the bar and the bench. A number of judgments of our courts have been subjected to criticisms, rightly or wrongly, here and there. And we believe that when a crop of senior lawyers are privileged to be appointed senior advocates of Nigeria, before they are swearing in, they should undergo an induction program of this nature to remind them of their duties and responsibilities as leaders in the profession. Now, this started about 6 years ago. This is the 6th edition of it, and we have consistently made the ethics and ethos and all those things that go with best practices in the profession the theme of the annual induction program of this nature.
Thanks for staying tuned. It's been argued that the justice system is the pillar on which a democracy system rests. But according to the Hague Institute for Innovation of Law, its 2023 study revealed that 81% of Nigerians face legal issues, with only 55% resolved in 12 months. So how do we ensure the goals of effective and efficient justice system? Here's another angle to the whole discussion.
What's your perspective of justice in Nigeria?
My idea of justice in Nigeria is where the administration of justice system meets the yearnings and aspirations of the people, where the people who are court users or who work within the system live knowing that people have a favorable view of them, and the user satisfaction of the administration of justice system is such that leaves everybody proud of the system we have in place. But anyone that leaves the people feeling that the justice system is not one that people can rely on, that while they may give you judgments, they do not give you justice. And that it takes a whole lot of time for you to get to the end of matters instituted in court. And you need to have a lot of money, and we need to know people within the system to be able to get a favorable judgment, or that the justice system is not such that you can predict or you can bank on to even enforce whatever judgment you get. Then there is a gap then between people's perception of what justice is and what it is in reality. And sadly, the negative is a situation in Nigeria where people feel that the court system cannot be relied on to resolve their conflicts.
Is there a big gap, and is this troubling to you?
Well, there's been an ongoing discussion, the perception, whether it's the perception that there is that big gap, is real. And I wouldn't want to be drawn into that argument. But for this conversation to be going on, and for those of us who are in the legal profession, and also those on the bench trying hard to explain that it's more of a perception thing but does not represent the reality, means that there's a problem. Because for the court users to keep arguing, criticizing the judges' judgments, never mind whether they have read it or not, and people also believing that the lawyers and the judges are the problems of Nigeria, means that there is a widening gap between people's expectation of what justice should be and what the understanding of what it is it's all about. And whether the perception is unfounded or is misconceived should worry us, because the way people feel about our ability to give them, render just and fair services to them, and for them to get justice from the system means a lot. And if that confidence by the public is gone, then it will erode our ability to represent ourselves as those who are in a position to guide them towards achieving justice within the framework that is provided by the laws and the Constitution.
How would you say the stakeholders in the justice sector have performed? You're also one of them.
Well, in the absence of empirical evidence, it would be wrong for me to keep trying to suggest who has failed or who hasn't failed. As lawyers, we may have failed when lawyers go to court and use all manner of legal artifice to delay cases, to prolong matters, to frustrate hearings, use the appellate system, and then where witnesses also who are part of the system give a suborn evidence or disappear and frustrate cases, or where law enforcement agents do not investigate cases well and rush to prosecute matters and do not even have a clear understanding of their cases and are ill-prepared to go on, or where the judges themselves are not diligent in the adjudication of matters, or where the wrong persons are appointed as judges to adjudicate over cases, or where the right persons are appointed but then they allow interest or corrupt practices or someone or bribery, anything to influence their judgment. So it will not be right for me to start judging, but if I'm asked specific questions about different areas that the different stakeholders may have contributed to the delays or lack of satisfaction, then it becomes easier for me to answer your question. But for me to suggest that one group has fared worse than the others would be presumptuous that I have empirical evidence about their ranking and standing.
What reforms would you say are available for the common man?
One of the biggest challenges to the administration of justice in recent times are electoral cases. Pre-election matters, for a start. They dominate our courts these days. The legislature keeps amending the laws, the Constitution, to give them priority. And so, their bad behavior ends up in the courts. The parties are unable to run their affairs in accordance with due process of law. Maybe we should look at whether these matters should continue to be justiciable, and if so, what kind of court should look at them and how far can these matters go? And should they continue to give them the primacy that will give them at the moment where these cases will go through the court system and disrupt the entire court system? We also have to look at the types of matters that the courts get involved in. Is it not time we talked about amending our Constitution to have intermediary appeal court systems for the states where such matters will end and can only proceed to the Supreme Court if they raise serious constitutional issues, as happens in other countries? We should also consider electoral reform, maybe where all the justices of the Supreme Court will sit to adjudicate on presidential election, so that the Supreme Court will be the only court to hear such matters. We should also look at a number of reforms that can be done to ensure that commercial disputes are resolved timelessly, not only electoral matters. We should also look at the mode of enforcing judgments. In Nigeria, for example, Section 84 of the Sheriffs and Civil Processes Act has made it impossible, almost impossible, I dare say, to enforce judgments against government, especially the federal government. It also has to talk about judicial reforms, appointing the right persons to the bench. And the appointment process has to be looked into. We have to make it more objective. There have been a lot of criticism about the way people are appointed to the bench, either the Higher Court, Court of Appeal, or Supreme Court bench. We should look at these issues and be able to tell ourselves the truth. Now, when all confidence in the judicial process is gone, people may well decide to take the laws into their hands. And the lawyers and the judges will be blamed for this failure. So all of us, instead of sitting down to blame one another for the fault, we should identify the challenges and sit down and find solutions to them.
On whose doorstep would you put these reforms?
So the NBA has a role to play as an association. the judiciary under on the platform of the NJC, the Honorable Attorney General has a role to play, and the National Assembly. We can work with the executive, we can work with the, that's why I said it's a multi-sectoral thing. And we identify those areas and agree on the reforms that need to be made. And the legislature should listen and then help put this place by way of bill before the National Assembly in place. Some may entail constitutional amendment, some may entail amendment of applicable laws, some will entail a change of attitude, some will entail what the judges do in the course of dispensing justice. So we need to have everybody know what they should do.
Are you worried about the current composition of the Supreme Court?
I am worried. Not worried because the number has dropped, but worried that it keeps dropping and we do not anticipate it and we don't take steps to prevent it from happening. And so what do I advocate as how to do this? First of all, we should stop this practice of appointing people who have lost a few years to spend at the Supreme Court and retire about the same time. And I say, before saying what I'm about to say this, I have nothing against presiding justice of the Court of Appeal being appointed to the Supreme Court, but there's everything wrong about insisting that only they are qualified to go to the Supreme Court. The Constitution has not made it such that it's a graduation system where you must move from primary to tertiary. You must be a High Court judge, and then you can only be a Court of Appeal judge having been a High Court judge. And you can't go to the Supreme Court unless you've been in the Court of Appeal. The Constitution says any person of 15 years post-call. Taslim Elias went to the Supreme Court bench without having sat in any court in Nigeria. Naman was Attorney General of the Federation, he went to the Supreme Court, and they did very well. And so the argument that, oh, how can they come from practice, they won't know how to write judgment, does not follow. Because those who go to the High Court more often than not don't have any experience about writing judgment. And it will be preposterous to suggest that a lawyer will not be able to write judgment simply because he has found himself in the Supreme Court. If we agree that the system needs reform, if we agree that there is need to inject fresh ideas into the Supreme Court and all the courts in the land, we should find an objective way of appointing people and not look at it as if this is our birthright. It is our ultimate promotion, having suffered so much, being High Court judges, being Court of Appeal. How can a lawyer just suddenly come and jump into the Supreme Court? We should remove that mindset. We should care about the institution. We should care about justice delivery and care about getting the best to the Supreme Court, to the bench. And also stop politicizing it as, oh, if this person comes in at 50 years, he will be a Chief Justice of Nigeria in some years' time. We should leave off those politics and focus on persons who will add value to the court. Focus on persons who will have long time to stay in the court and contribute to the judicial development of the country and have something to show. Justice Owens got to the Supreme Court at about, it was part of the panel and decided that Awolowo and Shagari in 1979. And he was in the Supreme Court till about 2007 or thereabouts before he retired. We should appoint people who have a long time to stay. And we should not appoint any person who will stay less than 5 years in the Supreme Court. And then when they also retire, or when we know they are going to retire, we should be able to trigger the appointment process so that as people are retiring, the replacements are ready to take over from them. Because we know when they will retire, we shouldn't be caught napping. It worries me that people who retired over a year ago are yet to be replaced. I don't know what the institutional challenges are, but I think whatever they are, we should be able to tackle them such to ensure that they don't happen again.
It's now time to take a look at some of the stories that made the rounds this week in the courtroom.
We begin with the report that the Supreme Court has ordered that the old currencies, 200 naira, 500 naira, 1,000 naira notes should continue to coexist with the new notes as they remain legal tender until the federal government puts a process in place for its replacement or redesign after due consultation with relevant stakeholders. A 7-man panel led by Justice Iyan Okoro gave the ruling following an application by the federal government seeking an order of the court to grant an extension of the time for the old naira notes to remain in circulation as a legal tender. The federal government also prayed the court to lift its March 3rd order, noting that the extension of time is necessary as it has not been able to print the volume of new notes that would enable a phase-out of the old currency before the December 31st order. The Lagos Division of the Court of Appeal has dismissed the petition of the All Progressives Congress candidate Patrick Tonye-Cole in the March 18 governorship election in Rivers State, challenging the victory of Governor Siminalayi Fubara of the People's Democratic Party. The APC candidate, who was present in the courtroom, had asked the court to direct INEC to declare him the winner of the election. The Rivers State Governorship Election Petition Tribunal had dismissed the petition of Mr. Tonye-Cole challenging the election of Governor Fubara on the grounds that the APC that sponsored Mr. Tonye Cole had withdrawn the petition against Governor Fubara's victory. The Ondo State House of Assembly and its Speaker has withdrawn its appeal filed before the Court of Appeal Abuja against the ruling of the Federal High Court Abuja, which stopped the planned impeachment of the Ondo State Deputy Governor, Mr. Lucky Ayedatiwa. At the day's proceedings, counsel to the Speaker and the Assembly, Dr. Remi Olatobura, told the three-member panel of justices of the appellate court that he has the instructions of his client to withdraw their appeal on the grounds that the parties in the matter have found a political solution to their problems and have signed an agreement to withdraw their appeal. The respondents did not object to the withdrawal. Justice Haruna Samani, who led the three-member panel, subsequently dismissed the appeal, having been withdrawn by the appellant. The trial of the former governor of the Central Bank, Mr. Godwin Emefiele, has commenced at the Federal Capital Territory High Court, Abuja, with the EFCC fielding 3 witnesses. At the resumed hearing, the first prosecution witness told the court that Mr. Emefiele was not the owner or a shareholder of the April 1616 Investment Limited awarded 1.2 billion naira vehicle supply contract by the CBN under Emefiele. Other witnesses who took to the stand told the court how various huge sums of monies were paid by the CBN into the April 1616 Investment Limited account, but the former CBN governor was not a signatory to the bank account of the company, and none of the payments had any link with the Emefiele name. Mr. Emefiele, who has not been able to meet his bail conditions, is still remanded at the Kuje Correctional Center.
And that's the program for today. If you missed any part of it, you can find it or past episodes on our YouTube channel. And yes, feel free to give us a feedback via any of our social media platforms. I'm Millicent Walker. Thank you for watching.